The Department of Justice just reversed its legal position on a major Second Amendment issue, not through legislation, not through a court ruling. The federal government's own lawyers walked into federal court and told judges, "We were wrong. The position we have been defending for years is not one we can defend anymore." When the DOJ changes its position on a constitutional question in the middle of active litigation, it does not just affect one case. It sends a shockwave through every court in the country where that issue is being litigated simultaneously. Judges take notice. Opposing attorneys immediately file supplemental briefs. The entire legal landscape shifts in a matter of days. I'm Sarah from GunGuidePro, 10 years in the firearms and constitutional law industry. And what the DOJ just did could accelerate the most significant expansion of Second Amendment rights in years. Let's break down exactly what changed and why it matters for your rights right now. Before we go any further, subscribe to GunGuidePro right now and turn on every single notification. We are a new channel building something genuinely important here. Real legal analysis for gun owners who cannot afford to be caught off guard. DOJ position changes trigger immediate legal developments, and those developments are moving right now. Every subscriber tells us this content matters and gives us the motivation to keep delivering this level of coverage. 2 seconds, completely free. Hit that subscribe button, hit that bell. Let's get into exactly what the DOJ changed and what comes next. Before I get into the specific change, I want to explain what a DOJ position reversal actually does to active litigation, because most people do not understand how significant this is procedurally. When the Department of Justice defends a federal law or regulation in court, it takes a legal position. That position becomes the government's official argument in every case involving that law across every federal circuit. District courts, circuit courts of appeals, potentially the Supreme Court. Every level of litigation is shaped by what the DOJ argues. When the DOJ changes that position, it does not just affect one case. It creates immediate ripple effects across every pending case involving the same issue. Judges who were weighing the government's arguments suddenly find those arguments withdrawn. Defense attorneys file emergency supplemental briefs citing the position change. Cases that were heading toward government victory suddenly look very different. A DOJ position change is the legal equivalent of the other team walking off the field mid-game. The cases do not automatically resolve, but the entire dynamic shifts overnight. And here is what makes this particular DOJ position change so significant for gun owners. The Trump administration's DOJ has been systematically reconsidering the legal positions taken by the Biden-era DOJ on Second Amendment issues. The Biden DOJ spent 4 years defending every gun restriction it could, arguing for broad government authority to regulate firearms in ways that many courts found constitutionally questionable. The Trump DOJ is now walking into those same cases and saying, "We no longer defend that position." Drop your state in the comments right now. Are you in a state where active federal litigation is challenging gun restrictions that the DOJ was previously defending? I personally read and respond to every single comment on this channel. The most significant and consequential DOJ position change of 2026 involves suppressors, and it has already produced real-world consequences in federal court. In U.S. versus Peterson, a case we have covered in detail on this channel, the Trump DOJ reversed the Biden-era position and admitted in open court that suppressors are constitutionally protected arms under the Second Amendment. That admission forced the Fifth Circuit to withdraw its original ruling and issue a completely new opinion. The government's own lawyers said, "The position we have been defending is wrong. Suppressors are protected by the Constitution." That single admission has enormous downstream consequences. Every case where the government was arguing that suppressors fall outside Second Amendment protection is now compromised. Every prosecution under NFA suppressor regulations that relied on the government's position that suppressors are not protected arms is now facing a fundamentally different legal landscape. Defense attorneys in those cases are filing supplemental briefs right now, citing the government's own admission. But here is the critical follow-through problem that the DOJ position change exposed. Even after admitting suppressors are constitutionally protected, the Fifth Circuit still upheld the NFA registration system. Their reasoning: the NFA functions like a shall-issue licensing system. If the government provides an objective process for registration, taxation, and approval, that system can survive Second Amendment scrutiny even when applied to protected arms. That holding is now the next legal battleground. The government admitted the item is constitutionally protected. The court said the registration system survives anyway. And gun owners and legal scholars are asking the same question. How can you constitutionally require government registration and a $200 tax stamp to own something the Second Amendment explicitly protects? That question is heading back to the Supreme Court. And the DOJ's own admission is the foundation of the challenge. Which politician in your state do you think has been most responsible for maintaining NFA regulations that impose criminal liability on people who own constitutionally protected items without the right government paperwork? Name them in the comments right now. The suppressor position change is the most dramatic example, but it is not isolated. The Trump DOJ has been systematically reconsidering Biden-era Second Amendment litigation positions across multiple issue areas on pistol braces. The Biden DOJ vigorously defended the ATF's pistol brace rule, arguing that the ATF had clear statutory authority to reclassify millions of pistol-braced firearms as short-barreled rifles requiring NFA registration. The Trump DOJ reversed that position, withdrawing the rule and conceding in multiple pending cases that the ATF had exceeded its statutory authority. Every case where gun owners challenge the brace rule is now in a fundamentally different posture. On the frame and receiver rule, the Biden DOJ defended the ATF's expansion of what constitutes a regulated firearm frame or receiver, specifically targeting so-called ghost gun components. The Trump DOJ has been reconsidering those defenses, acknowledging in some proceedings that the rule stretched statutory definitions beyond what Congress authorized. On felon in possession challenges, the Biden DOJ uniformly defended the federal felon in possession statute against all Bruen-based challenges, arguing that lifetime gun bans for all felons regardless of offense type have clear historical foundation. The Trump DOJ has shown willingness to distinguish between violent and nonviolent felons, a distinction that multiple circuit courts have already found constitutionally meaningful under the Bruen historical tradition test. On cannabis users and gun rights, the Biden DOJ defended the categorical prohibition on gun ownership for anyone who uses controlled substances, even cannabis users in states where it is legal. The Trump DOJ has signaled more openness to the constitutional challenge that a 1968 federal statute cannot categorically disarm people for using a substance that is now legal in most states. That question is before the Supreme Court in U.S. versus Hamani. What is your honest reaction to a DOJ that is systematically reconsidering legal positions that courts have been finding constitutionally questionable for years? Type long overdue or creates new problems in the comments. I want genuine analysis from this community. Here is the practical impact of these DOJ position changes on active litigation and on your rights as a gun owner. Cases already in court get stronger immediately. Every gun rights organization that has been fighting against positions the DOJ has now abandoned, Second Amendment Foundation, Firearms Policy Coalition, Gun Owners of America, suddenly has a much stronger hand. When the government's own lawyers say we no longer defend this position, courts take that seriously. Cases that were heading toward government victory are now being reconsidered. New challenges become more viable. When the DOJ signals it will not vigorously defend a legal position, it encourages new litigation challenging that position. Gun rights organizations are right now identifying cases to file that would have been harder to win under a DOJ still committed to maximum government authority. The shift in DOJ posture changes the litigation calculus significantly. But here is the critical limitation you must understand. A DOJ position change is not a court ruling. It is not a law. It does not immediately change what you can legally do or own. Laws remain in effect until courts strike them down or Congress repeals them. NFA regulations remain enforceable even while the DOJ concedes suppressors are constitutionally protected, because the Fifth Circuit said the registration system survives. ATF rules remain on the books even while the DOJ reconsidering their defense, until courts formally vacate them. Do not make decisions about your firearms based on DOJ position changes alone. The legal transition is real, but it is not complete, and acting ahead of where courts actually are creates serious criminal exposure. What is your prediction? Will the Supreme Court ultimately rule that the NFA registration system is unconstitutional as applied to items the government itself admits are Second Amendment protected arms? Type NFA falls or registration survives in the comments. I want serious legal predictions from people following these cases. Here is your practical action plan, because understanding this DOJ shift only matters if you know how to act on it correctly. Step 1. Understand what changed and what did not. DOJ position changes affect litigation strategy and legal precedent development. They do not change the laws currently on the books. NFA regulations still apply. ATF classifications still exist. Know the difference between a DOJ shift and an actual legal change in your obligations. Step 2. Follow the specific cases that DOJ changes affect most directly. U.S. versus Hamani on cannabis users and gun rights. The ongoing NFA suppressor challenges in Texas federal district courts. The pistol brace cases working through multiple circuits. These are the cases where DOJ position changes are most directly producing legal developments. Subscribe to GunGuidePro. We track every one of them. Step 3. Support the litigation organizations doing the work. DOJ position changes create opportunities, but converting those opportunities into permanent legal victories requires sustained litigation. Second Amendment Foundation, Firearms Policy Coalition, Gun Owners of America. They need resources to move fast when the legal landscape shifts the way it just did. Step 4. Contact your congressional representatives about permanent statutory reform. A future DOJ can reverse these position changes. A future administration can go back to defending every restriction aggressively. The only permanent protection is congressional action, clear statutory language that removes the ambiguities that have been exploited for decades. Here is the absolute bottom line. The DOJ just changed its legal position on suppressors, admitting they are constitutionally protected arms. It is reconsidering its defense of pistol brace regulations, frame and receiver rules, and several categorical gun ownership prohibitions. Every one of those changes creates immediate legal momentum in active litigation. And the legal architecture being built right now on the foundation of a DOJ willing to acknowledge constitutional limits on gun regulation could produce the most durable Second Amendment victories in decades. Here is what you do right now. First, subscribe to GunGuidePro and hit that notification bell immediately. We are a new channel, and every single subscriber gives us the motivation and resources to keep covering these developments at this level. The cases triggered by these DOJ changes are moving fast. Second, smash that like button and share this video with every gun owner you know who has been affected by NFA regulations, brace rules, or any ATF classification that the DOJ is now reconsidering. Third, answer all 3 questions in the comments right now. What state are you watching from? Which politician in your state do you hold most responsible for defending unconstitutional gun regulations in court? And what is your favorite Second Amendment ruling of your lifetime? Heller, McDonald, Bruen, or the Cargill bump stock decision? I personally read and respond to every single comment on this channel. Gun Guide Pro is just getting started. The legal battles coming over the next 12 months are going to define gun rights for the next generation. Be here for every single one. Stay informed, stay armed, stay free. I'm Sarah from Gun Guide Pro. See you in the next one.